It is crucial to differentiate between the General Data Protection Regulation, GDPR, and the ePrivacy Directive, EPD. Despite their interconnectedness, these two legal frameworks serve distinct purposes and have separate compliance requirements. Yet, many lawyers and tech professionals mistakenly conflate the two, leading to significant compliance oversights. This is a follow-up article on my article Danish E-commerce Awards, Are All Winners Breaking the Law? And has been written to help both industry professionals and business owners in understanding why they need to be compliant with the ePrivacy Directive. The fundamentals of GDPR and ePrivacy Directive. GDPR. Scope: GDPR is a comprehensive data protection regulation that applies to the processing of personal data within the EU. It focuses on how personal data is collected, stored, and used. Key principle: GDPR emphasizes lawful processing, data minimization, transparency, and user rights, such as the right to access, correct, and delete personal data. ePrivacy Directive. Scope: the ePrivacy Directive, often referred to as the Cookie Law, specifically governs electronic communications and the privacy of data in the digital space. This includes cookies, tracking technologies, and other methods of storing information on user devices. Key principle: Article 5(3) of the ePrivacy Directive mandates that storing or accessing information on a user's device requires prior consent, unless strictly necessary for the provision of an information society service explicitly requested by the user. The technical requirement argument, a misconception. A common argument from both legal and technical professionals is that certain tracking technologies are technically required for the website's functional operation, and therefore, exempt under GDPR. While GDPR does provide exceptions for necessary data processing, this does not override the consent requirements stipulated by the ePrivacy Directive. Understanding GDPR exceptions. GDPR Article 6(1)(f). This article allows for the processing of data if it is necessary for the purposes of legitimate interests, provided it does not override the rights and freedoms of the data subjects. Technical necessity. Some argue that certain cookies or trackers are essential for the website's basic functionality, such as maintaining a user's session during a shopping experience. Under GDPR, this could be considered a legitimate interest. ePrivacy Directive's stricter standards. Article 5(3) of the ePrivacy Directive. This article requires explicit consent for storing or accessing information on a user's device, unless it is strictly necessary for the provision of an information society service explicitly requested by the user. Strict interpretation. The ePrivacy Directive interprets strictly necessary very narrowly, meaning only those cookies or trackers that are essential for the core functionality of the website, e.g., shopping cart cookies, are exempt from prior consent. Functional needs versus third-party services. First-party essentials. Functional needs that are truly essential to a website's operation, like maintaining a shopping cart, can be considered necessary under the ePrivacy Directive and may not require prior consent. Third-party non-essentials. Third-party services, such as analytics, advertising networks, or even third-party consent management platforms, do not fall under this strictly necessary category. These are considered non-essential for the website's core functionality and thus require prior informed consent. Common misconceptions. Technical requirement argument. Often, third-party tracking technologies are implemented under the guise of being technically required for the website's operation. However, if these technologies are not critical to the immediate functionality that the user explicitly requests, they cannot bypass the ePrivacy Directive's consent requirement. Non-essential services, for instance, third-party analytics services, while useful for improving website performance and user experience, are not essential for the website's basic operation and thus require prior consent. First-party analytics. Consent is still required. A common misconception is that first-party analytics, such as those provided by Aserex Analytics or Matimo Analytics, do not require consent under GDPR. However, the ePrivacy Directive makes it clear that any form of tracking, including first-party analytics, requires prior informed consent. Legal perspective. Matimo Analytics. Many users load Matimo Analytics without seeking prior consent, assuming it is permissible under GDPR's legitimate interest clause. However, under ePrivacy Directive Article 5(3), even first-party analytics that store or access information on a user's device need prior consent. AsserX Analytics. Similarly, AsserX Analytics is designed to comply with these stringent requirements, ensuring that user consent is obtained before any tracking takes place. Third-party consent solutions. The compliance challenge. Common non-compliant practices. Remote execution. Many third-party consent solutions, such as cookie information and cookiebot, execute remotely within the user's browser. This practice inherently involves loading third-party scripts before obtaining user consent, violating Article 5(3) of the ePrivacy Directive. November 14 clarification. As of November 14, 2023, the guidelines have made it unequivocally clear that no third-party tracking or consent solutions can be loaded without prior consent. The third-party consent solution business model is no longer valid as consent needs to be set prior to load of the third-party consent solution, which is only possible first-party. The GDPR excuses. Why they fall short. Many professionals argue that their tracking technologies are covered under GDPR's technically required exception. However, the ePrivacy Directive is more specific and stringent in this context. Here's why the argument is void. Prioritization of consent. ePrivacy Directive explicitly prioritizes user consent for any form of tracking technology. This overrides the broader exceptions provided under GDPR for legitimate interests. Scope of applicability. GDPR governs personal data broadly, while the ePrivacy Directive specifically targets the act of accessing and storing information on user devices, making its consent requirement more applicable to cookies and trackers. No loopholes. The clarification from the EDPB on November 14, 2023, reinforces that consent must be obtained first, effectively nullifying any attempt to bypass this through GDPR exceptions. This counts for all types of tracking including server-side tagging. Conclusion. Ensuring compliance. To comply with both GDPR and the ePrivacy Directive. Prior consent. Ensure that no third-party trackers or consent solutions are loaded before obtaining explicit user consent. Transparent practices. Clearly inform users about the data being collected and its purposes. Regular audits. Conduct regular compliance checks using tools like the AsserX Privacy Scanner, which leverages the EU's EDPS inspection tool to ensure adherence to both GDPR and ePrivacy Directive requirements. By understanding and implementing these distinctions, organizations can better navigate the complexities of digital compliance, avoiding potential fines and fostering greater trust with their users. Ronnie K. Gothard Christensen / Viking Tech Guy. Creator, AsserX.io. Join our community and catch up with all the latest information and news on Telegram https://t.me/asserx_official_community. References. General Data Protection Regulation, GDPR. ePrivacy Directive, Directive 2002/58/EC. EDPB Guidelines on Article 5(3) of the ePrivacy Directive. Background on the ePrivacy Directive. Establishment. The ePrivacy Directive, also known as the Cookie Law, was established in 2002 and updated in 2009. It sets out specific rules regarding the privacy and protection of personal data in the electronic communications sector. Key requirement. Article 5(3) of the EPD mandates that storing or accessing information on a user's device requires prior consent unless it is strictly necessary for the provision of a service explicitly requested by the user. Role of the EDPS and EDPB. EDPS. The European Data Protection Supervisor is an independent supervisory authority responsible for ensuring that EU institutions and bodies comply with data protection laws. The EDPS also plays a significant role in providing guidance on interpreting these laws. EDPB, the European Data Protection Board, is an independent European body that ensures consistent application of data protection rules throughout the EU and promotes cooperation between the EU's data protection authorities. New guidelines and their impact. Guidelines issued on November 14, 2023. The EDPB issued the guidelines February 2023 on the technical scope of Article 5(3) of the ePrivacy Directive. These guidelines were developed to provide detailed clarification on the application of Article 5(3), addressing ambiguities and ensuring consistent enforcement across the EU. Instant effect. While the guidelines themselves are not new laws, they serve as authoritative interpretations of existing law. They provide clarity on how the ePrivacy Directive should be implemented and enforced. Because the EPD is already binding, the guidelines have an immediate effect as they interpret already existing obligations. Why this matters? Clarification. The guidelines clarify that any form of tracking technology, including cookies and other trackers, requires prior informed consent, regardless of whether they are first-party or third-party. Consistency. They ensure that national data protection authorities, DPAs, have a consistent framework for enforcement, reducing discrepancies between member states. Compliance. Businesses must adhere to these guidelines to remain compliant with both GDPR and the ePrivacy Directive. Non-compliance can result in significant legal risks, including fines and other penalties. Summary. Understanding the interplay between GDPR and the ePrivacy Directive is crucial for ensuring full compliance. The November 14, 2023, guidelines underscore the necessity of obtaining explicit consent for any tracking technology, reaffirming the stringent requirements of the ePrivacy Directive. About the ASRX Privacy Scanner. The ASRX Privacy Scanner is a powerful tool designed to ensure that websites comply with the stringent requirements of the ePrivacy Directive and GDPR. Using the EU's EDPS, European Data Protection Supervisor, inspection tool, the ASRX Privacy Scanner conducts thorough scans of websites to identify non-compliant elements, including cookies, trackers, and beacons. ASRX also offers a free Privacy Advisor AI assistant that helps to explain the scanned results from the EDPS inspection tool and offers concrete recommendations on what is needed to resolve compliance issues found in the scan result. By leveraging these tools, businesses can receive detailed reports and actionable insights to rectify compliance issues and avoid potential fines.